Morning. My name is Maritza Reyes, and I trust that everyone can hear me. If not, please let me know. I guess. Okay, good. So I'm going to start my presentation now by introducing myself, although I believe that I was introduced a minute ago. My name is Maritza Reyes, and I am an attorney, and I'm an independent scholar now. I was a law professor for 15 years until I was terminated from my employment in effective April of 2024. And so when I attended the first conference, July 23, 2024, it had been, I guess, over 3 months since I had been fired, effective. But the termination began in February 2024. The mobbing had been ongoing, and as background for my presentation today, I'm just going to, share briefly of the facts, which I have done at the prior presentations. So if you notice, my 2024 presentation began with a self-represented attorney's experience and why I chose to make workplace mobbing part of my litigation strategy in the federal courts. So the next year, because the first time I share more of the technical, the next year I share more of the personal experience, including something that I thought was important to share, which was how did I make the decision on whether I, wanted to go through litigation, knowing what workplace mobbing does to a person, knowing the toll it takes. I had to do a cost benefit analysis, and so that's what I talked about at the 2025 Niagara conference. I see that I am in a different space in terms of I am an attorney, and I was also the target, and so I hope that my experience, right, knowing what I know from both sides, will hopefully serve to enlighten as we go forward with this development of workplace mobbing as a scientific principle. So now I am going to talk specifically this year about how to qualify workplace mobbing for expert testimony in the federal courts. If there's time at the end, I'll update a little bit on the litigation aspect as to the personal. So I'm going to begin with assuming that you're not lawyers, but you're educated, college educated individuals. So I don't want to dumb it down too much, but I also want to give you the basics. So in the federal courts, there are the federal rules of evidence. And why I chose to focus on the federal courts, it's because that's where a lot of scientific principles are sort of tested or introduced to the general public. Think about DNA testing and how now that's presented in cases. It was introduced at some point when it was a developing scientific principle in the court systems. And the federal courts have these uniform federal rules of evidence. And a lot of state courts, right, because we have a dual system, the federal system and the state system of courts. A lot of the systems, the state systems also follow the federal rules of evidence. So I'm going to give you just a brief introduction to testimony in terms of the federal rules of evidence. You have two types of testimony, and that would be lay testimony, which, the average person can give lay testimony. And they are often called lay witnesses. And then you have opinion testimony by experts. So lay witnesses, the rule for lay witnesses is that, we can all be lay witnesses as to the facts that we experience about what we have personal knowledge. Like if I say, I was at the conference on July 21, 2026, that's factual lay testimony. I have personal experience. Now, opinion testimony, it would be something like, and I thought the conference was great. Well, what kind of opinion testimony is allowed in the federal courts from lay testimony, a lay witness? It has to be rationally based on the witness's experience. It has to be helpful to understanding the testimony of the witness or determining a fact in issue in the litigation. And It cannot be based on scientific, technical, or other specialized knowledge, because that's within the scope of the next rule, which is about expert testimony. But let's think about what kind of opinions lay witnesses can give. Well, these are things that normally, in our everyday human experience, we make assessments, and to be able to say it factually all the time, we couldn't. For example, the weight of a person. You can say, I think she weighed about 160. Imagine if we walked around with a scale, having to weigh people to then be able to make that assessment. And so I have a list here: the appearance of a person or things, identity, the manner of conduct, competency of a person, degrees of light or darkness. For example, think of car accidents. Was it light? Was it dark? Those are the kinds of opinion testimony that we allow for lay testimony. And then you get into the substance of my presentation, the testimony by expert witnesses. So first of all, when people think of expert witnesses, they often think about, maybe somebody very highly educated at a college degree. And you'll hear me throughout my presentation today. I'm going to take the liberty of implementing my analysis through an expert that we have within us, and that would be Dr. Kenneth West Hughes. But you don't have to get to the level of Dr. Kenneth West Hughes to qualify for expert witness testimony in the federal courts, because if you notice, a witness who's qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise, if the proponent demonstrates to the court that it is more likely than not that, and I'm going to get into the rest in the next slide. But notice that knowledge, skill, experience, training, or education. And so one of the contributions that I hope to make is that I hope to encourage people within our space here, and maybe if you can encourage others, to become experts in the matter. And it can be by knowledge, skill, experience, training, or education. I'm not a psychologist, but I can imagine that we can have, for example, clinicians, psychology clinicians that can develop expertise, right, by your knowledge, skill, experience, training, or education. Some of you will develop it through research, but we need to develop this knowledge to be able to qualify. Once we have that qualification, then we have to get to the next part of the analysis. Before expert testimony is allowed in a federal case, you have to show that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. The testimony must be based on sufficient facts or data. The testimony must be the product of reliable principles and methods, and the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. So to put in context, my federal case was a Title VII federal case. And within the Title VII federal case, I had a hostile work environment cause of action. That's where I introduced the workplace mobbing testimony. Because with regards to Title VII, hostile work environment, you have to show that it is so severe and pervasive. And so in my prior presentations, I likened why I chose, and I saw the similarities between workplace mobbing and a hostile work environment. Of course, in a Title VII cause of action is one of the protected grounds: race, sex, national origin, and that type. But on the helpfulness analysis, when I proposed expert testimony, the question, the other side attacked whether it would help, whether it was necessary, because in order to help, it's about helping the jury. And they said, well, anybody knows about bullying. Anybody knows about personality conflict. I use that to say, well, the fact that they're saying that is that they don't know what workplace mobbing is, because it's totally different. So part of the education that we have to do about workplace mobbing is informing of how this scientific principle is complex, that it's not just bullying or personality conflicts or workplace conflicts. And I think that I've heard today in the presentation yesterday, we have to acknowledge the institutional aspect of it, so that, you know, we need the testimony because most people have not lived through a workplace mobbing or observed it, even if they have observed bullying or personality complex. So the next requirement, that the testimony is based on sufficient facts or data. And when I prepared my complaint in my case, I was very factual. I mean, I had dates, times, who said what, the email, the dates, quoting from the emails, because it had been ongoing for a long time. And I'm very evidence driven. When I state something, I like to have evidence to support it. So I had a lot of documentation, and I was able to include what became facts or data for the analysis for expert testimony. And then C, the testimony is a product of reliable principles and methods. And here I use Dr. Westhu's factors. And in expert testimony, you have to show the reliability of those principles and methods. And so because I'm not an expert in the material, in regards to how the testimony would develop, I relied on the scholarship of Dr. Westhu's, I relied on his factors, and I relied on the report that he prepared. And then the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. So once you establish that those factors are reliable principles and methods, then now you have to apply the factors to the specifics of the case, and that's where the sufficient facts or data that I included in my complaint helped to apply to the facts of the case. So notice that the form of expert testimony can be opinion or otherwise. So these are some ways in which it can be presented. It can be presented as dissertation or exposition of scientific principles relevant to the case. It can be in responses to hypothetical questions, or it can be otherwise, because the federal courts leave it open for development. Now, the way that I introduced expert testimony was generalized testimony. So it wasn't a finding as to my particular case. But what I wanted to show was the subject matter, workplace mobbing. That's what I wanted to highlight. And educate both the judge and the jury about what workplace mobbing is as a scientific principle. So for generalized testimony, it has to be a qualified expert. The testimony must address a subject matter on which the fact finder can be assisted by an expert, and that was workplace mobbing as it relates to hostile work environment. The testimony is reliable, and the testimony fits the facts of the case. When experts are working on developing this, they have to work with the lawyer who hired them, right? Because the lawyer has to bring the facts of the case and put together the argument for why this expert testimony should be allowed. And I think that that's sometimes difficult, that communication between the attorney and the expert, because they're coming at it from different directions. So expert testimony in the federal courts developed through case law. So we started with what we call the Fry test. And under that test, the scientific principle had to be established by general acceptance in the particular field in which it belonged. And so basically at that point, it was the different expert scientific communities that were deciding what is generally accepted. And there was a lot of bias within that, because I've learned, you know, within the scientist community, who gets whose principles or scientific, you know, innovations get accepted or not. There's a lot going on with that in terms of bias, politics, and everything. So then the Supreme Court in the Dauber v. Merrill Dow Pharmaceuticals case in 1993, notice the dates. From 1923, we had that test, and then we went to 1993 to a different test. So 70 years passed. Now, Merrill Dow Pharmaceuticals and the prodigy that came after that, I call these the trilogy, General Electric and Kumho Tire. They developed this new analysis of how the federal courts were going to analyze expert testimony, so that it no longer was just the Fry test, which became a factor. So it was no longer going to be controlled by the scientific communities as to what was generally accepted. Now the judges, the federal judges, are going to be the gatekeepers of what becomes expert testimony. So that, can be good or bad. There were a lot of, proponents, there were a lot of critics of it, but it allows, I think, to develop theories in the courts. So whether the expert's technique or theory can be or has been tested, whether that technique or theory has been subject to peer review and publication, the known or potential rate of error of that technique or theory when applied, the existence and maintenance of standards and controls, and whether the technique or theory has been generally accepted in the scientific community. So I want to, encourage again within our community as we develop this as a scientific principle to keep in mind these factors, to develop the scholarship, to develop the case analysis, because let's face it, this is, going to have to be done through case analysis. How many can we have? The quantity of the analysis and cases that we, that we can have evidence to support with data. There's a non-listed factor in the analysis because the analysis under the factors is not exclusive. Those are not all the factors. You can always make arguments that there should be other factors considered depending on the scientific principle and the facts of the case. But bias is something that is always going to be considered. So experts sometimes and often get paid for their testimony. That can lead to questions of, are you doing it because you're getting paid? So I think that at the beginning, if we could develop, identify experts within our area who are willing to come in cases just to establish the principle in the federal courts. And Dr. Kenneth Westhus was very helpful in that regard, because we're going to need this at the beginning. And then hopefully, later on, then it can be expert testimony for pay all the time. So in a nutshell, is the expert testimony reliable? Is it helpful? And is it relevant to the facts of the case and the decisions that the jury is going to be making? So in the analysis on their Daubert, the courts look at whether the expert is proposing to testify to scientific knowledge that will assist the trier of fact to understand or determine a fact in issue. So if a fact is already established, then there's no need for an expert testimony. But what is workplace mobbing? Did it happen? How does it happen? That was a fact in issue as regarding hostile work environment. To go through the 1 and 2, you're going to do whether the reasoning or methodology underlying the testimony is scientifically valid and whether that reasoning or methodology properly can be applied to the facts in issue in the case. What is it that the court is going to scrutinize? Because first you have to get through the court. In terms of the court accepting that the testimony will be put forward to the jury. The court is going to look at the principles and the methods used by the expert and whether those principles and methods have been properly applied to the facts of the case. Again, this is going to be preparation by both the expert and the attorney. And another thing, like I said at the beginning, it doesn't have to be somebody as highly educated as Dr. Westhus, because you can be qualified solely on experience as an expert. When the qualification is based solely on experience, and I'm saying this for the clinicians that we have, the ones who are not doing, research necessarily in publishing, they have to explain how that experience leads to the conclusion reached, why that experience is a sufficient basis for the opinion, and how that experience is reliably applied to the facts. So this would probably, be clinicians who are treating patients of workplace mobbing. Now, I don't know how many are going to be able to do this in terms of the quantity of the numbers that they would have to treat. So the qualification based solely on experience, the court may ask whether this preparation is of a kind that others in the field would recognize as acceptable. And one of the examples that they give in the advisory committee notes to the federal rules of evidence is, think of a perfume tester who's able to distinguish among 150 odors at a sniff. Well, how many has he sniffed? It's going to be about the quantity to be able to have sufficient reliability. So the courts are going to look at quantitative rather than a qualitative analysis regarding the facts and data an expert relies upon. The witness is going to may give expert testimony on the facts or data prepared for by someone else. For example, in my case, the complaint was prepared by me as a party and attorney. So those would be the facts or data in my case. And the witness may rely on hypothetical facts or data if they are supported by the evidence. In judging reliability, the court is not only looking at the underlying theory or principle, but again, it's always about applying reliably to the facts of the case. So unless the court orders otherwise, an expert may state an opinion and give the reasons for it without testifying to the underlying facts or data. However, once the expert testifies on direct examination, which would be the examination by the party who called him or her as a witness, then comes the cross-examination, which is going to be where, the other side gets to ask about those facts or data. My advice as an attorney is, get those facts or data and what you think will come out on cross-examination on the direct anyways, because then the expert is a little bit more relaxed and you have more control over the presentation of that analysis.
You have about a minute to wrap up, please.
Okay, so with that said, I want to thank Ching Li Ming, and I want to thank Dr. Kenneth Westhuse and Rick Pell-Steele, because this conference would not be possible without, their innovative thinking about the need for it. This is a lifeline, and this is something that I think it's not going to only help those of us present at this conference. And my hope is that we're going to develop it beyond just ourselves. And I am choosing to do it through the advocate way, that I know as an attorney. I hope to publish also on this, but also encourage all of you to let's connect as a network to see how we can continue to develop it wherever you are, in whatever country you are, in whatever systems you operate. So thank you very much for your time today.